Today I will be speaking on the topic of temple freedom. Before I get into the topic, let me just narrate what happened with me a few days ago. I was at this place called Mahabalipuram in Chennai, and I was always under the impression that the structures at Mahabalipuram are religious structures. This was the first visit that I had ever made to the place as an adult, and I must have seen the place as a kid several years ago. But this was the first visit as an adult. So I expected an air of religiosity, an air of devotion, and perhaps a temple-like treatment of the place. I enter the place only to notice that practically every vigraha or every statue or every sculpture of every deity which is present within the premises, people were sitting on it with their footwear, people were taking pictures. In fact, at least in the south, the concept of a garbhagriha is supposed to be extremely, it's sacred. Other than the priest, even devotees are not supposed to enter the place. There are hundreds of rules which are supposed to follow to enter the place. People were standing right next to the idols of the deities and taking selfies and whatnot. It was not just Hindus who were entering the place. People of every faith were entering the place with their footwear on. And as someone who comes from the south of India, this is almost inconceivable. Perhaps in the temples of north, it's acceptable for people to go and touch the Shivalinga or to perhaps touch the deities' structures themselves or the idols themselves. In the south, we are not supposed to do these things. That's basically the tradition that we follow. Now, there is a decent chance that these are the remnants of the old tradition that we've been practicing for generations together. That's a possibility. And therefore, I could say that the temple traditions of the south still perhaps retain the original practice to a large extent because they've been relatively safe from foreign influences, if I may call it so. I was aghast at what was going on in the place. I wanted to understand. So, for instance, you have a temple dedicated to the goddess, to the mother goddess. Then you have a temple which is dedicated to Indra. Then you have a temple which is dedicated to the sun god. Then you have a temple of Vishnu, who is in the Anantashayana pose. So each of these are practically temples. So my question to him was, for all practical purposes, if this is a temple, why is this being used as a tourist place? So that takes you to a very fundamental question. What makes a temple or a certain structure a temple in the first place? What does it have to satisfy in terms of its basic ingredients for it to be a temple? So apparently the history of the place is this. Between the war that happened between the Pallavas and the Chalukyas in the 6th and 7th century, during which period the construction of this particular structure was taking place. Thanks to the war, the construction stopped as it is. So what you see in Mahabalipuram are not completed structures, but these are structures which were left as it is during the period of the construction itself. So typically, a temple is supposed to be complete when the kalash is actually kept at the top of the temple on the spire itself. And you will notice in each of these temples that the kalash is still in front of the temple. It has not been placed on the top of the temple on each of these 5 structures, the Pancharatha temples I'm talking about. So therefore, it is possible for somebody to technically argue that this is not a temple and therefore it doesn't deserve to be treated as a temple. But my sense of, as a lay person was, if there is a murti inside, for all practical purposes, it must be treated as a temple. Even if, let's say, the prana pratishthan has not taken place or the consecration which is associated with the construction of a temple has not taken place, the presence of a murti alone is sufficient because, at least as far as the average Hindu is concerned, the presence of a murti is supposed to sanctify the place to a very large extent. It has a certain connotation to it. So the bare minimum requirement that I expected from the place was people should not be allowed to use footwear once they enter the particular sanctum sanctorum. Then there must be a distance that must be maintained from the temple. People must not be allowed to enter the temple itself. Imagine men and women sleeping right next to Vishnu in Anantashayana pose, and that was exactly what was happening in the place. Now, there could be a lot of people who could argue that exposing these structures to visits by people of all faiths, regardless of their creed, actually helps in popularizing the structure. I don't believe so. For me, you need to be able to inspire at least the same amount of respect, if not more, when people enter our places of worship. And unless and until they're willing to treat it with the same dignity and with the same respect that we impute to it, perhaps their entry must be barred. That's more or less the object behind prohibiting foreigners into the Srirangam temple or non-Hindus into the Srirangam temple or the Tirupati temple. Why is this important? I asked the tourist guide who is responsible for the maintenance of the place. And he told me it's the Archaeological Society of India, ASI. And the footfall in the vacation season and the weekends is, to me, sufficient to ensure that there are enough funds for the upkeep of the particular place, to employ enough manpower, to employ enough, let's say, security guards, and perhaps even engage a priest to undertake what needs to be done to ensure that the temples get the usual rituals and the regular puja is undertaken. He said nobody is interested. A lot of people have tried, but the ASI has decided that this is a place of heritage importance, of cultural importance, but not of religious importance, and therefore it shall not be treated as a temple. Now, I wonder, who do I blame for this particular situation? Government apathy, as far as I am concerned, is something that we have to take for granted. And that is a given in all walks of life, in all parts of life. There is only so much that you can expect from the establishment itself. And you can't expect non-Hindus to treat our places of worship or our places of religious importance with the same amount of reverence or respect. But what do you make of the common Hindu who goes to these places, has absolutely no regard for the typical traditions or the typical rites and rituals that are supposed to be followed with a certain temple? That takes you to the central problem when it comes to temple freedom, which is of apathy. Now, it could be said that because they are not aware of the actual issue that relates to temple freedom, they are not in possession of the facts, they don't know who controls the temple and its resources, maybe that's why there is a sense of apathy. But my experience shows that ignorance is always not the necessary causality for apathy. Apathy itself is a separate vice or an evil that needs to be addressed on a standalone basis. And that takes you to a central question as to why is it that in these places most people don't seem to understand that the temple is a representation of your civilization. It is a representative, it's a representation of the journey that your civilization has taken in the thousands of years that it has existed. There is a political reason for this, at least in the south. And let me, a good part of the focus of this talk is going to be about the temples of the south. I'll come to the temples of the north in a bit. In the south, thanks to the political movements since 1917, starting with the self-respect movement, the Justice Party movement, or the Dravidian movement, for good or bad, the temple has been treated as the institution of a single caste, of a particular caste. It has been demonized as an institution of the Brahmin. It has been associated with Brahminism intrinsically, and perhaps with some justification, because there was a practice of not allowing members of a certain caste to enter these temples. That did happen. Therefore, it was important for the government to step in to ensure that temples are open for everyone. Be that as it may, the association of the temple with a certain caste is the primary reason that others don't seem to perhaps have the same sense of hurt or the same sense of concern when the temple as an institution is under attack from multiple directions, from multiple dramatis personae, if I may call them so. Therefore, there is a caste factor that plays in this. But then, my sense of the history of temples itself has been that every temple has always belonged to one particular community or the other. While it was open to everybody to enter a certain temple, the ownership of a particular temple or the administration of a particular temple has always been held by a particular denomination, not necessarily the Brahmin always. The Brahmin may perhaps have performed the role of a priest as the officiator or the interceder between the deity and the devotee. But beyond that, as far as the administration is concerned, it has been in the hands of the community which has run that particular institution. In fact, I may even say that there are exceptions and significant exceptions to even this particular practice, which is to say, there are temples which are controlled and owned by non-Brahminical denominations and which are officiated by non-Brahmin priests as well. And there is a significant number of examples for this. There are a number of tribal temples in Kerala, there are a number of Shiva temples in Tamil Nadu, which are officiated by non-Brahmin priests. That doesn't make them any less Vedic, let's be clear about it. They may still fall within the Vedic fold, within the mainstream Hindu fold, but the stereotype that the temple is a Brahminical institution is a politically motivated stereotype which has come back to haunt us today, and that needs to be shattered first. So for instance, if you go to Karnataka, there are any number of temples owned by the Lingayat community and officiated by the Lingayat community, and these are Shiva devotees. So why is this important? It is important to understand that the seeds of dissension and the seeds of divide on the caste lines which were sowed at least close to a century ago continue to have a bearing as far as our apathy towards the temple as an institution is concerned. How has this helped others? Whether we believe it or not, whether we see it or not, at least for the non-Hindu and at least for someone who comes from the outside, he has identified that the temple plays the role of the nerve center of the Hindu society for all practical purposes. This is because the temple performs more than the role of a place of religious belief or more than a place of worship. The fact that it has a social function, the fact that it has an economic function, that it plays the role of even arbitrator of social disputes is something that the outsider has understood, which is why the temple as an institution has suffered repetitive and successive attacks over and over again from anyone who's wanted to dominate this part of the country or this part of the world. This has happened over and over again. Apart from the fact that the temple has always attracted a lot of wealth because of endowments from rulers, endowments from devotees, which makes it more or less, let's call it a crucible of wealth of sorts, where it has been in possession of a significant amount of resources. Let's take a modern day example. If you go to the to Udupi, the Udupi Mutt, or perhaps even if you go to the Kukke Subramanya temple, while langar as a concept is typically associated with a Gurudwara, these temples have had a rich and an uninterrupted history of running langars, not just for people who visit the particular temple, but they supply food to schools and to working professionals even today. I was recently told that close to 7 tons of rice is cooked on a daily basis in Kukke Subramanya. And it goes to schools, it goes to working professionals. How does this impact the ecosystem? Let's try and understand this. They do not use modern equipment for, they in fact use firewood. And the firewood is sourced from the forest around the place. And it is sourced exclusively from the tribal community, which ensures that there are enough communities whose livelihoods are taken care of by the temple as an ecosystem. Why is this important? It has prevented conversions to a significant extent in that part of the country. Livelihoods are taken care of. Several communities are made to feel as stakeholders as far as the temple ecosystem is concerned. In contrast to the popular perception that there is a hierarchy of sorts where people are ill-treated and discriminated against, these examples never come to light. No light is shone upon them. These examples exist as well, which is why conversions as a phenomenon have been relatively low in these parts of the country. So people who are interested in social justice, people who are interested in empowerment of backward castes or downtrodden people must realize that they have more to gain from putting faith in the temple as an institution, as a great leveler, as opposed to treating the temple as the source of all hegemony and discrimination. This is important for us to understand. Therefore, if you were to remove the cultural aspect or the civilizational aspect as well from the entire discourse of temple freedom, the fact that it has real-time utilitarian benefits for, let's say, forging communal harmony or casteist harmony is also important for us to understand. That it plays the role of telling people that you're part of this fold, you're no different or you're no inferior to anybody else. You also have to understand another thing. So I'll give you one more example. The Vishwakarma caste in the south is a non-Brahmin caste, but that is the only caste which otherwise has been given the sole responsibility of sculpting the deity, which is why the patron deity is Vishwakarma himself. It's a dying breed today. It's almost a dying breed today, and since they're not in a position to incentivize the successive generations to take up this particular activity, this particular profession, others have stepped into this particular profession, and today you have non-Hindus who are basically sculpting the deities, which may be a welcome move. I don't see a problem with it, but there is a technical issue here. There is a nuance that needs to be understood here. The Vishwakarma caste, or anyone who takes up the profession of a sthapati, has thousands of rules that he has to follow. Fasting, rituals in the morning and whatnot. There are thousands of rituals. Can we confidently say that when people from other faiths, professing other faiths, take up this particular profession, they will respect these practices, they will adopt these practices, they'll observe these practices in the building of the deity or in the sculpting of the deity? The answer is a clear no. In several instances, it's actually a no. Apart from the fact that you don't have enough manpower to pull from your own community, there is also the problem that there has been state pressure to encourage people of other faiths to take up what is otherwise a profession that requires a certain amount of religious devotion. This has happened. Therefore, we are now entering the realm of state interference in this. So let's try and understand how this all starts. Let's start with the temples of the south and the history of the temples of the south, and then go to the temples of the north. So around 1840 is when the British decide to actually interfere with the administration of temples in the south. But the actual legislation that comes into force is a legislation of 1927, which was then implemented in the Madras Presidency, which applies to large parts of what are Tamil Nadu today, Karnataka, and other places as well. In fact, the Tamil Nadu legislation is the parent legislation for most of the southern legislations that govern the administration of temples, including the Andhra Pradesh legislation, the Karnataka legislation, so on and so forth. Why is it that this legislation comes about in 1927? Why not before and why not after? The social justice movement had picked up steam from 1917 to 1927. And the Aryan invasion theory had gained a fair amount of traction, not just from the British, but also from members of the Dravidian movement who decided to use this and then started vilifying all those institutions which they associated with the Brahmin caste. And since the temple stands in their eyes as the foremost institution in the hands of the Brahmin, they wanted the Brahmin to be dispossessed of that particular institution. It's surprising that they didn't realize that there are at least 5 or 6 castes which depend on the existence of the temple as an institution itself. So in the process of targeting one particular community, they ended up affecting all of the communities who were casualties and collateral damage as far as this particular movement is concerned. So the British takes control of this and they take charge of these institutions. The irony is the manner in which the British ran these institutions, it was much better than the way we run these institutions as on date. The schemes that were settled by the British in the running of these institutions, in the running of their resources, in the management of these resources, were far more equitable, were far more, let's say, imbued with foresight, and were meant for the use of the resources in an efficient manner to prevent corruption of any sort, and for the redistribution of the resources within the community itself, of course, with the British government taking a cut as a fee for the administration, which the Indian state continues to do so at 16% per annum. Now, between 1927 and 1946, the Tamil Nadu legislation goes through at least 10 different amendments, out of which the most important amendment is of the year of 1935, if my memory serves me right. And a certain chapter 6A, was introduced to the legislation, which perhaps is the most pernicious and obnoxious part of the entire temple legislation, because it allows the state to notify a certain temple. So notification as a process simply translates to the government saying that the circumstances are ripe for the state to step in and take charge of the temple. So notification simply means the state says that from today on, this temple shall be under state control. But at least it had certain circumstances in which such takeover was permitted and envisaged, certain limited circumstances. So logic and common sense should tell you that unless and until those circumstances are attracted a temple cannot be notified and shall not be notified, and the state shall not step in. The marching powers of the state are not triggered as long as those circumstances are not triggered. I'll give you the factual backdrop as on date. There are 34,265 temples spread across the state of Tamil Nadu alone. All of them under state control. So this begs the question as to whether the state thinks that each of the 34,265 temples merit the takeover by the state. The funny part is at least 60 to 70% of these temples make an annual income of less than or equal to 10,000 rupees. So where is the question of maladministration or misappropriation or mismanagement of funds in a temple that makes less than 10,000 a year? Therefore, this takes me to a very different concept altogether. But let's just go back to again 1920s and 30s. We are still talking of a period when you did not have the Constitution of 1950. Therefore, secularism as a concept and the separation of the temple and the state and the church and the state was still not codified, so to speak, and therefore you did not have a constitution under whose framework you can examine these activities. So this legislation again gets amended and you bring in the, so the 1927 legislation continues. In the year 1950, something happens which triggers a monumental shift in the history of these legislations. Shirur Mutt in Udupi, the Chidambaram temple in the then South Arcot district, the Guruvayur temple, and another temple in Karnataka, all these temples are notified under the dreaded chapter 6A for takeover by the respective governments. So each of these temples, they approach the Madras High Court and the respective high courts, challenging the government order which notifies the takeover of the temples by the government. Apart from challenging the government order, they also challenge, so we are talking of 1950 now. So since it's 1950, the constitution has already come into existence. Therefore, they also challenge the constitutionality of multiple provisions of the 1927 legislation, along with the challenge to the government order before the Madras High Court. During the course of the litigation, the old Act of 1927 is repealed and the new legislation of 1951 comes into force. So the petitioners amend their existing petitions and they now challenge the 1951 legislation along with the government order which notified those temples. The Madras High Court practically agrees with every contention of all the petitioners, strikes down all the salient provisions of the 1951 temple legislation as being unconstitutional for taking away the rights of the community to administer its own temples under Article 26, and goes on to say that the right of religious denominations to administer their own religious institutions has been eviscerated and emasculated by the legislation of 1951. So the state appeals against this and this goes to the Supreme Court. So this forms the backdrop of the landmark decision of 1954 known as the Shirur Mutt case, where the Supreme Court goes on to strike down and most of these provisions. More or less it agrees with what the Madras High Court has said, but it also disagrees with some of the aspects that the Madras High Court had held as unconstitutional. But by and large, the salient unconstitutionality and the manifest illegality of these provisions and the legislation was upheld by the Supreme Court in 1954. One would have hoped that a decision from the highest court of the land, the highest constitutional court of the land, would have been a strong enough message for the state to mend its ways and limit the scope of its interference with Hindu religious institutions. But they come out with a new legislation in 1959, which is the legislation in force even today, which paraphrases the very same provisions which were struck down by the Supreme Court as unconstitutional. So, lo and behold, that here the state itself could be hauled up for contempt for having passed a legislation containing similar provisions or near identical provisions which were struck down by the Supreme Court as unconstitutional in 1954. One would have hoped that the moment the legislation came out in 1959, somebody would have challenged it and it would have been again held as unconstitutional. But then Hindu apathy plays a huge role in this because these legislations were challenged for the very first time by the late Shri Swami Dayanand Saraswati in 2012. So from 1959 to 2012, nobody bothers to challenge these provisions. Nobody bothers to take a look at these provisions. Nobody asks themselves, how is it that the state has been given such a free pass where it thinks that it is okay for it to willy-nilly violate the verdict and the mandate of the Supreme Court itself. Now, here I'll introduce another aspect, which is to say this petition has been languishing between the Supreme Court for the last 5 years. My question fundamentally has been that the Supreme Court has found all the time in the world to hear the triple talaq hearings during the course of a summer vacation on a day-to-day basis. The Supreme Court seems to find enough time to hold hearings with respect to the right to privacy. But somehow the Supreme Court has not found the time in the last 5 years to hear these petitions, which are ripe for final arguments, considering that at least 34,000 temples in one particular state are under state control. In this petition, which was filed by Swami Dayanand Saraswati, 3 state legislations have been challenged, of Andhra Pradesh, of Pondicherry, or Puducherry rather, and the state of Tamil Nadu, all of which go back to the parent legislation of Tamil Nadu itself, because more or less they are recasting of the same legislation. So all 3 legislations are before the court. Now, when a provision is challenged on the grounds of unconstitutionality, the test is simply this: is the provision inherently unconstitutional, or is a constitutional provision being abused by an executive officer? Which is to say, धारा अपने आप में प्रॉब्लमैटिक है या फिर धारा को कोई उसका दुरुपयोग कर रहा है? That is the question. If it falls into the second category, it's not a case of unconstitutionality, it is a case of executive abuse. If it falls into the first category, it means that the provision itself facilitates corruption and takeover by the state. And that is our case. And we managed to show a lot of examples of theft and whatnot and abuse and whatnot before, and not just abuse, of blatant unconstitutionality before the court. In the petition itself, of course, it's not had a hearing. While the petition is languishing before the Supreme Court for the last 5 years, there are significant developments that happen before the Supreme Court in other cases. So the landmark case of the Chidambaram priests approaching the Supreme Court for their right to be appointed as priests and their right to manage the temple is something that went before the Supreme Court, and Dr. Subramania Swamy was the one who was leading this entire litigation from the front. So this was the case of a community called the Podu Dikshitars, whose livelihood depends entirely on the revenue that comes from the Chidambaram temple, which is otherwise known as the Sabhanayagar temple. It's basically a temple that's dedicated to Shiva. Of course, there was also a certain history that says that's one of the few temples where Shiva and Vishnu coexisted within the same compound. Be that as it may, it's popularly known as the Chidambaram temple. And the issue before the Supreme Court in the Chidambaram case was simply this: can the government, in the name of mismanagement of the affairs of the temple by the trustees of the temple, appoint its own representatives and take over the administration of the temple completely, to the exclusion of the community's representatives? Apart from that, for how long can the state representative continue to be in charge of the temple administration? These are the 2 questions that were before the court. I think on the 6th of January 2014, Justice Ranjan Gogoi, if my memory serves me right, comes out with a landmark decision basically saying that when an executive officer is appointed by a state to administer a certain temple, 2 conditions have to be followed. 1, he has to give reasons the state has to give reasons as to why the appointment of a state representative is necessary. What is it about the temple administration that shocks the conscience of the state, warranting the interference of the state? Point number 1. Therefore, आपको बताना पड़ेगा कि यहाँ पे कोई घोटाला हुआ है, इसीलिए state का इसमें हस्तक्षेप करना जरूरी है. It's important for the state to explain this in writing. These are basic principles of natural justice. Second, since the temple otherwise is the resource of the community and must be in charge and must be controlled by the community itself, the stay of the executive officer must be limited only to that period which is necessary to rectify the wrong. You came in here on the premise and on the excuse, on the pretext, in the backdrop, in the context of saying that there is a mismanagement as far as the temple is concerned. The moment the mismanagement is rectified and cured, you need to get out of the place. That's basically the mandate of the court, which is to say, the stay of the state in the temple administration cannot be ad infinitum. It cannot be for an indefinite period of time. So these two landmark decisions come about, which in fact only strengthen our case before the Supreme Court with respect to the Swami Dayanand Saraswati petition. Now, here is the funny part. So these appointment of executive officers in the state of Tamil Nadu happens under this provision called Section 45 of the Act, of the 1959 Act. But Section 45 itself says that for you to appoint executive officers for the administration of temple, you have to come out with specified rules which say that these are the circumstances in which an executive officer shall be appointed to a certain temple, to its board of trustees. Now we are talking about a legislation that came in which year? 1959. So one would have expected that the rules would have come out either in 1959 or at least in 1960 before any further appointments of executive officers are made to temple administrations. These rules come out for the very first time in November 2015. Between 1959 and 2015, appointments are made across the board with respect to each of the temples in the state of Tamil Nadu where executive officers are appointed. So one, appointments happen without any rules being in place. Second, appointments are made without written orders. Three, there is no appointment order in certain instances, and yet there is an executive officer who is appointed to the place. There are all three categories of abuse that have taken place as far as the state of Tamil Nadu is concerned. This is only with respect to administration. In terms of the legitimacy of administration, here are certain other examples of the pernicious effect of temple administration by the state. The Hindu Religious and Charitable Endowments Board, or the department, is the department that is in charge of temple administration in most of these states. In 2017, there was a judgment by the Madras High Court, which I happened to defend before the Supreme Court successfully at that, where the Madras High Court had found the HRC department and the police officials of the state of Tamil Nadu hand in glove with thieves of temple art and temple architecture. So people who are otherwise supposed to be the defenders of the civilization, who are supposed to be the custodians of temple property, were actually hand in glove with police officials and thieves. And this was the stinging castigation that came from the Madras High Court, where it went on to recognize that you have violated the religious rights and cultural rights apart from being neglectful of your duty and your primary mandate in the manner in which you have discharged your duties. So fortunately for us, the Supreme Court upheld this decision. Why did this decision come about? And I'll explain the context as well. So the Tamil Nadu police has a certain wing called the idol wing, which looks after theft of temple idols. And there is a senior police officer, Mr. Pon Manikavel, who's been so diligent in going after temple thieves and theft of temple art. He has started multiple cases, and huge kingpins who've always had a free pass in all these years, they're now behind bars. For some weird reason, God knows who was pulling the strings and what happened, there were orders issued for transfer of this police officer. And it is against this particular transfer, apart from the fact that he was also in charge of the theft of these temples in this particular case, that a petition was filed by a public-minded activist, a public-minded Hindu activist, Mr. Venkatraman, who approached the Madras High Court on the grounds that we have at least one police officer who seems to be interested in pursuing the temple thieves and in retrieving temple art. Even he's going to be transferred without any proper reasons being given. Therefore, something must be done about it, because this is a case where he has found that people from the police department of Tamil Nadu itself have been responsible for facilitating the theft. Therefore, he must be allowed to do it. In fact, the name of the police officer who was actually facilitating the theft, I think, was perhaps Kader Basha. And he's on the run. He's absconding at this stage. He's made crores of rupees from this, and he is now currently on the run because of the investigation initiated by Mr. Pon Manikavel. So he was about to be transferred, and against these transfers and this kind of interference from the state, the petitioner had approached the Madras High Court. The Madras High Court upholds his contentions, records that despite foreign invasions, despite, in fact, I think the word used even is Muslim invasions by the Madras High Court, we have still been left with a vast heritage which has been relatively untouched compared to what has happened in the north, the ravages that the north has suffered. Therefore, it becomes our duty to protect all of this for future generations for the sake of posterity. And therefore, it recognizes the right of Hindus, the cultural and religious right of Hindus, to expect the state to protect this culture, which I think is a landmark judgment in its own, because for the very first time, we have a judgment of an Indian court which recognizes the state's duty in protecting Hindu culture. So this decision is challenged by the state of Tamil Nadu before the Supreme Court, and that appeal is dismissed on day one. And the court says that this gentleman shall not be transferred, his appointment shall continue, and he shall continue to be in charge of these cases. And in fact, he must be given all the support he needs to prosecute these cases and bring the culprits to the book. So that's what happened. But you have to understand, how many such cases will people continue to fight? How many such battles can people continue to wage? How many people are interested in taking up these causes? Therefore, what this calls for is not 1,000 bandages, but a massive revamp and a massive overhaul of the structure that exists when it comes to the control of temple institutions. Here, let's just pause for a moment and take a look at what is the legal structure that applies to it. The only circumstance in which a religious institution and its administration can be interfered with by the state is under Article 25(2) of the Constitution. And this is only with respect to secular, financial, or economic aspects of the administration of a temple. And for that, you need a legislation. The state cannot walk into a temple on its own. You need a legislation which gives the state the powers to do all of this. Of all the communities in this country, only the Hindu community's institutions are interfered with by the state through multiple legislations. Most people don't even know that the Bombay Trusts Act is by and large used for controlling temples in the state of Maharashtra. Apart from that, you have a legislation that controls the Siddhivinayak temple. There's a legislation that controls, I think, the Mahalakshmi temple. There's a legislation that controls the Pandharpur Vithala temple. So there are at least 4 legislations in the state of Maharashtra itself. Then you have a legislation in Bihar. Then you have a legislation in Himachal Pradesh. You have a legislation in Andhra Pradesh. You have a legislation in Karnataka. You have a legislation in Telangana. You have a legislation in Tamil Nadu. You have a legislation in Odisha as well. What does this tell you? The simple logic that I am trying to present, and it's not a simplistic logic, it's simple, which is to say, if I have the power to interfere with the religious institutions of all communities across the board, and I choose to exercise that power only with respect to one community, this for me is a textbook and a classic example of discrimination and abusive use of power to the detriment of one particular community. It's almost as if you're trying to make an example out of this community and you're giving this impression that this is the community where corruption abounds in its religious institutions, and therefore you need interference by the state as far as its administration are concerned. I think perhaps the second largest owner of real estate in this country outside of the state would be the church. And I don't think it's impossible for us to conceive that there is perhaps mismanagement even with respect to the real estate owned by the church, by the officials of the church. How many instances of state interference and state intervention have we seen across the board in all these years, where any state government or the central government has deemed it fit to interfere with abuse of church-related properties, or for that matter, even Waqf properties? While I'll have to make a slight digression here, which is to explain why is this issue so important. Is this an issue which is just a concern for the elites of the Hindu society? Or is this something that has a tangible bearing on the lives of the average Hindu as well? That needs to be understood. That point needs to be drilled into us for the simple reason that as long as it remains a storm in a teacup, as long as it remains the concern of a handful of elites, there is no way that we will ever find traction as far as this particular issue is concerned. The RT, for all practical purposes, is a failure. The state administration and the state's ability to educate its people is almost a failure. The one institution that can perhaps play a role and that has the resources to play a role and fill this particular void is the temple. Between 1959 and 2015, the number of lands or the quantum of lands which the state of Tamil Nadu has alienated, which belongs to temples, is almost 47,000 acres. Alienated without reason, without proper documentation. Imagine if all these lands were put to good use by the temple, it is leased out at market price, and the revenue from that is used to educate Hindu children. And you also use the resources to keep Hindu traditions alive through your educational institutions. We can achieve so many objectives in one fell swoop in a single shot. In fact, quite a few temple activists, particularly Mr. T.R. Ramesh, who is part of the Temple Worshippers Society in Tamil Nadu, according to him, if the Mylapore temple's land were to be used and the lease revenue is put to good use, children across a 1 mile radius of the temple can be educated free of cost. We cannot expect the state to be concerned with every tradition which is dear to us. The state may not have resources to employ, the state may not have resources to earmark, but the temple has those resources. And the temple's resources can be used for maintaining gaushalas, for keeping a lot of traditions alive. Traditions are kept alive not just for the sake of posterity or for its sake itself, but because those traditions and them being kept alive translates to livelihoods for a lot of people who depend on those traditions, right from the sculptor. So I give this popular example always, which is to say that in the state of Kerala, you have a bunch of communities or castes called as the Ambalavasis, or people who are dependent on the temple or whose professions are related to the temple in one way or the other. People who make flowers for the temple, people who actually are temple musicians, people who perhaps I don't know, they have people who perform for the temple. At least 5 different castes, their professions are and their livelihoods are connected to the temple itself. Therefore, revival of the temple ecosystem is not just a civilizational achievement, it is a utilitarian achievement from a practical standpoint as well. It is an employment generator in its own. It has the resources to address a lot of causes. Let me give you a different example. A lot of these martial traditions, native martial traditions, have practically died today because their primary source of patronage was the temple itself. I don't think the concept of an akhada connected with the temple is unusual in the north. How many such akhadas are alive today? How many such akhadas continue to function? Do they have the resources to continue their martial traditions, be it the Mallakhamb or whatever it may be? In the south, you will look at the Silambam practice, which is basically the martial tradition using the bamboo, that's more or less dying. Let's understand this. Some things are not done for the sake of profit. You do it so that the tradition is kept alive. The state does not have either the inclination or the resources to invest in these things because it perhaps may not be a revenue generator or a profit generator for the state. It is for the temple as an institution to take care of this. But if the temple as an institution itself is in the hands of the state, and the state is not interested in putting these resources to this kind of a use, then what is the point of having a temple in the first place? From the standpoint of even addressing the issue of conversions, if the temple's resources were freed, then the temple will have enough to take care of its own people. It will have enough resources to invest in its own people. But this takes us to a different question. It's not as if all temples across the country are in the hands of the state. So the question that is bound to arise in the minds of a common Hindu is, this may be a problem which is endemic to the south of the country, where the temples are in the hands of the state. But what do you make of those temples which are in the north of the country, which are outside state control? What is it that they have done to invest in the community, to better the lives of the people, or have invested in education or in hospitals or whatnot? That is a fair question, that is a legitimate question. Therefore, perhaps we must as a community put more pressure on our religious institutions to stop hoarding their resources and start investing in the community. But this is very distinct from the central question of whether the state can have any say in this. These are two different issues. One is a question of institutional reform, which is for the community to introspect and put pressure on, where you ask your temples to be a bit more civic minded, to be a bit more community minded, and ask them to invest in the people as opposed to covering themselves in gold. That's a different question altogether, and that's a legitimate expectation that the community can have from its community leaders. However, this does not justify the intervention of the state. For all those people who worship and deify the concept of secularism, my mind boggles at the suggestion that the state has the right to control the religious resources of the religious institutions of one particular community. This violates all canons of secularism as understood in any civilized jurisdiction. The state's limited power. So, for instance, there is a specific provision of the Constitution, which is Article 31A or B, which goes on to say that for the purposes of addressing mismanagement, for a temporary period, the state can take hold of a certain piece of property and then give it back once that particular piece of property is, or that particular mismanagement is rectified. This is regardless of whether it is otherwise state property. So, for instance, let's assume there is a certain ashram, and this was an issue after, this had arisen after the demise of Satya Sai Baba in the south. Thousands of crores were supposed to be in the possession of the trust, of the Satya Sai Trust, all of which, for all practical purposes, is public money. Therefore, if the state had believed that there is a possibility of mismanagement of those funds, it could have taken charge of the administration of the trust for a certain period of time, rectified the problem, and it would have had to give it back. Be that as it may, the power has to go back to the trust. The administration must go back to the community. There is no concept either in constitutional law or outside the Constitution which envisages or facilitates or allows the state to sit and stay put in the religious institution of a community for eternity. But this has been happening as far as the Hindu community is concerned. This is an issue which I think must find enough traction. It has not found enough traction. It's important for people to understand what kind of a bearing it has. There's one more aspect that I think we must address. And I'll draw an example from a recent litigation that we had fought before the Madras High Court. A common slur that is accused, or let's say that is hurled at Hindu religious institutions is, they discriminate devotees on the basis of the amount that they pay for a darshan. So if you're able to pay higher, you get special darshan. If you're not in a position to pay, then you get a common darshan. And this more or less generates a stereotype that Hindu religious institutions are largely money-minded and they're basically meant for the rich and not for the poor. If you're affluent, if you're well-heeled, and if you have the resources, you get special treatment as far as Hindu religious institutions are concerned. I'll give you one example of what has happened in the state of Tamil Nadu. So we run a group which basically pursues Indic legal causes, and as part of this we had visited a couple of temples only to realize that the system of a special queue based on the payment of an extra fee is an imposition by the HRC department of the state of Tamil Nadu without the permission of the trustees of the particular temple. So we had written, or we had filed an RTI application asking them as to where do you draw the power to impose this kind of a system as far as the temple is concerned. After all, if you're a state appointee, you need to show the source of power when it comes to the imposition of such a structure. The response comes to us saying there is no rule, there is no provision. This was done at the discretion of the commissioner of the HRC department. The decision is taken by the state, but the community and the institution is saddled with the stereotype that it is a money-minded institution. So we challenged this before the Madras High Court, and our fundamental question was, if he cannot trace the source of his power to impose this kind of a rule, then the rule must die. There is no reason for such an imposition to survive. We get more or less what I would call a consolation prize, where the Madras High Court went on to hold that all people, regardless of the money they pay or they don't pay, they shall have access to darshan from a common point, and it identifies the common point as far as the certain temple is concerned. But even then, the Madras High Court fails to address the central question as to, regardless of where people can stand and have darshan, what was the basis of the imposition of the rule by the state in the first place? That question has not been addressed. So we will be taking this up before the Supreme Court. But the big picture point I'm trying to make is this. If the temple's resources are in the hands of the state, It does not have the power to invest in hospitals without the permission of the state. It does not have the power to invest in educational institutions without the sanction of the state. It does not have the power to run the temple's daily functioning without the approval of the state. And yet, the temple and the community are constantly lampooned and ridiculed for actions which are taken by the state. This is to address the common myth and the common perception that be it philanthropy or investment in the community is something that Hindu institutions are fundamentally incapable of. Perhaps certain temples may be accused of that despite not being under state control, but as far as the temples in the south are concerned, by and large, they are in the hands of the state, to the extent that under the legislation of Tamil Nadu, the annual budget has to be approved by the commissioner before funds can be sanctioned for daily activities. Here's the funny part. If you're aware of the Dravidian movement, you will know for a fact that the Dravidian movement solely targeted one religion despite its professions of atheism, which was the Hindu religion. Hindu gods would be taken out in a procession, rotten eggs and tomatoes would be thrown, the deities would be slippered and whatnot. All of this would happen. The leaders of this movement and their birthdays are mandatorily celebrated through special pujas in Hindu temples under instructions from the state. So Hindu religious institutions are forced to worship or to pray for those people who vilified them. This is the extent to which it has gone. At the heart of the problem is something more slightly legal and technical, and I'll touch upon that, which is this. The state has the power only to interfere with secular aspects of temple's administration and not with performance of religious ceremonies at all. That is the legal position. However, the performance of every religious activity involves use of resources. And use of resources falls within the basket of the secular basket. Which means, if I have to conduct a puja or I have to open a bhandara for a certain season, the resources I need to undertake that activity have to come from the coffers which are in the hands of the state. The state has to approve of it, which means directly or indirectly, for all practical purposes, the performance of the religious function is in the hands of a secular administration. Therefore, the religious activity, its strings are connected to the state administration, and it has been reduced to a puppet in the hands of the state puppeteer. That is the actual effect, and that is the manner in which the legal framework has played itself out. So I get asked these questions. Assume that the state vacates these temples and the administration is left altogether to the community. How do you propose to go about administering these institutions? I think most of these questions come from a my baap mentality, where we are constantly looking up to the state for support in every activity, in every part of life. My answer to this question is threefold. One, other communities don't seem to need the state's intervention to run their institutions, so why do we? Two, why do we underestimate the innate self-reliance and entrepreneurial spirit of the Hindu community to take care of its own institutions? After all, Jains have been able to take care of their own institutions. Four, state stepping into the administration of the temple is a phenomenon only from 1927. So before 1927, the community was in control of its resources, at least for the large part. Therefore, we don't have to assume that the moment the state leaves, there is a vacuum which cannot be filled. This is not an election after Nehru's death where you end up asking, after Nehru who? So if the state leaves this particular space, the vacuum can be filled. And how can it be filled? The answer is this. We have to understand that each temple, notwithstanding the fact that it is open for every community to visit, or rather every community within the Hindu fold to visit, it is a denominational institution, which means it is run by a certain group. It is run by a group which has a specific identity. And therefore, representation must come from that particular group, and they must be in charge of their temples. However, the concern in these cases is, how do you prevent caste discrimination from finding its way back to the entry of temples? if the temple's administration is reverted and it's given back to the community, will we not have a system where again caste discrimination is rampant in the temple administration? This again can be addressed, which is to say, you can have a representation from the core community which belongs to the denomination of the particular temple, and you also ensure that you have representation from a Dalit community, or you also have representation from female members of the community, which is a structure which is already proposed in a couple of legislations. Therefore, the bogey or the fear of a Brahminical hegemony taking over the institution again is a false bogey, and that should not be used as a pretext to justify the state sitting in our institutions. For me, what is surprising is this. A community which otherwise displays a tendency to rely upon itself on all aspects of life, and it is practically given up on the state's ability to help it, seems to be putting so much of faith in the state to manage its religious institutions. I'll give one stark example. The Devaswam minister of Kerala took a lead role in participating in the beef festival that was organized in the Shankaracharya University in Kerala, which is in the place called Kaladi, which is the place where Shankaracharya was born. These are the kind of people who are presiding over our institutions. How do you expect these people to value your sentiments, to value the resources, or to put those resources to the benefit of the community? It was recently found that close to 40 employees of the Tirupati Devasthanam are non-Hindus, including the top executive officer. She is a Christian. Surely I don't need to prove my secular credentials by inviting members of other communities and other faiths to preside over my religious institutions. Can a Hindu be appointed as the Minister of Minority Welfare? You are after all living in a Hindu country, which is 80% Hindu. In which case, don't you trust the Hindu to take care of minority interests as well? But if you don't, why is it that I should trust you to take care of my institutions? These are some spaces which are specifically identified and which are specifically preserved only for communities themselves and members of the communities themselves and nobody else. Under the stewardship of people who are in charge of the Tirupati Devasthanam, we have seen a number of churches mushrooming in and around the Tirupati temple itself, when there is an agreement and there is an arrangement that at least within a certain distance of the temple there shall be no temple, or there shall be no church or place of worship of any other community. Crosses are planted willy-nilly on all hilly terrains available. If you go to Goa today or if you go to Tirupati today, you will see crosses planted across the place. In fact, there are instances where church and church officials have indulged in encroachment of Hindu land because that land is under the control of the state, and the state will not take action against anybody who's associated with the church. And any legal action that is to be taken by the temple to protect its resources will have to be done through the executive officer, who is an appointee of the state. The common refrain that we have heard from most of these people is, whenever we take these actions, there is no resistance from the community, or there is no resistance from the representatives of the community who are sitting on the temple boards. How will there be any resistance when there is a state appointee who's presiding over the administration of the temple, who is basically the person who handshakes with the state? In other words, the state has a representative in the board, and that representative is liaising on behalf of the board with the state, and is bound to dance to the tunes of the state. Therefore, no decision that is taken by the state is free from influence. It's not with free will that the temple boards act in accordance with the state's wishes. Therefore, as far as I am concerned, the state has the right to regulate the administration of temples, but not to administer the temples itself. And our legal position as far as this particular issue stems from a clear reading of Article 25(2) of the Constitution, which goes on to use the word restrict or regulate, which means you can have a law which says that temple boards shall function on these lines, but you can't have a law which envisages the entrenchment of the state in the temple administration itself. And this is the clear distinction between regulation and supersession or takeover. So as far as we are concerned, this is the legal position. We hope that in the coming years, we will find a solution to this. However, no legal action or law is effective in itself unless and until there is societal pressure, unless and until there is a certain amount of social engineering that takes place. We have to understand that notwithstanding the number of ashrams that come about or mushroom in this country, in all parts of the country, the temple happens to be the average Hindu's place of first choice when it comes to finding spiritual solace or religious solace. The average Hindu is the one who has still kept this religion alive, who has still kept the faith alive. It's not the elites. Therefore, if the institution in which the masses put their faith is eroded, is eviscerated, is emasculated, and is deracinated and de-Hinduized, nothing will survive of this faith in the future. Therefore, for the sake of posterity, from a civilizational standpoint or from a social standpoint, it is important for us to understand that the Reclaim Temples movement is perhaps the most important movement for us to protect ourselves. In the long run, temples will perform a greater role in forging and fostering Hindu unity, in forging a civilizational unity. Therefore, as long as they remain in the hands of the state, this is going to be impossible. All resources that we need for the renaissance or the revitalization or the revival of this community are in the hands of the temple, which is in the hands of the state. Therefore, the state needs to make an exit at the earliest. That is our case.